I think the fundamental conflict between real estate developers and lawyers circles around risk. Lawyers' responsibility is the management of risk, and managing risk takes time. Real estate developers, while concerned about risk, just want to get their deals done. And so to the extent a developer can narrow the scope of what the assignment is, I think the relationship can be more effective and work better. I have a younger lawyer that I sometimes meet with, and she's advising a developer client. They want to take on a partner, and the head of the development company told the development partner that they could have a profits interest. 20% profits interest. The thing is that there are so many permutations of what a profits interest is and how it's going to work. And does that mean that they have to put in to cover expenses? How is that going to work? And this young lawyer, as she is supposed to do, started asking all these questions. And her developer client said, "Why are you trying to kill my deal?" That is the number one tension between lawyers and developers, is once you start asking all the questions as an attorney that you need to ask.
That's your training.
Correct. The developer starts to get impatient. They've made a deal, 20% profits interest, just paper it, figure out how that's going to work. The fact of the matter is lawyers are not in a position to make those decisions for their clients. The client needs to make those decisions for themselves and be willing to work through that issue.
And on the flip side, if the lawyer doesn't ask that question in advance and it blows up in the aftermath, they'll say, "Why didn't you think to ask this? Aren't you a lawyer?" So that's the...
Correct. That's the tension. And I actually think at the end of the day, that's one of the areas where developers could do a better job of managing their attorneys, which is sometimes having more direct, frank conversations about exactly what issues the developer is really concerned about and what the lawyer should not be concerned about. And letting the lawyer document that is such an effective way to get deals done. It's not the way that people often act, and developers can be thrown off by a lawyer trying to say, "I'm not going to advise you on this issue, you're assuming the full risk," because sometimes clients do view lawyers as insurance policies, which makes lawyers very nervous.
So you're saying a developer, if they're absolutely dead set on fast-tracking the process, can advise their lawyer of such, and the lawyer to cover themselves for allowing said process to happen. I notice I'm using even more legal language.
I do notice.
Can basically write it out and document that and say, you, the client, wanted to fast track this, and jump over the negotiation of topics A, B, and C. I'm noting that you take the risk. So that's how the lawyer both acquiesces to the request to do that and covers themselves legally on the back end.
Right. And I mean, I think that's the perfect solution. Sometimes lawyers are uncomfortable with that because there are certain attorneys who cannot accept that their clients won't do things the quote-unquote right way. But our job is really to advise as to risk and solve the problems we're charged with solving.
So defining the scope frankly and in a legally binding way. So that's a first one. What's some other stuff?
Right. I think some of the other issues are, once you get into the actual deals, right, you've agreed on your scope. A lot of times developers are bad at laying a good foundation for their transactions. What happens is you give or reach an agreement that you don't even understand what you've done. As a developer, you're loath to tell your lawyer, "I don't know what you're talking about." No one wants to do that.
Right.
No one ever wants to admit to their lawyer that they're not quite sure what the issue is that's in play. And so what I will frequently see is clients going out and trying to negotiate an issue without fully understanding what that issue is. And that can be a disaster. So I actually had a client negotiating a hazardous materials provision a few years ago. And in that case, there was going to be some pre-site work that was going to involve the use of hazardous materials on site. Again, the definition of hazardous material is very broad, and so these were everyday chemicals that you would not be remotely surprised to find at Walgreens or the grocery store. And so what happened was the seller wanted to limit so much the quantities that they could use that they wouldn't actually be able to do their work. And so this was a significant issue in the transaction. There also was another issue in that the seller wanted constant reporting as to what was being used on site. And it was going to be unduly burdensome. It was going to prevent the developer from doing what they needed to do. And again, we aren't talking about materially significant chemicals. And so the developer went into the negotiation and viewed it as a tit for tat. I will give up one and get the other. And the problem was the one that they gave up was they agreed to use in these quantities that weren't going to work for them, which is not a curable default, instead of agreeing to give the sworn statements as to what they were using, which you could cure, right? Because all you have to do then is give a statement saying, oh, you're right, we're using Ajax in addition to all the other chemicals we're using. And so that was a clear case to me where the client just did not understand what the issue in play was, viewed the negotiation as I need to give something up, and then made the wrong choice in what to give up. Now, really, neither should have been given up because there was a meeting of the minds as to what was going to go on. And this was just a seller who wasn't quite sure also, right? You have two parties who don't fully understand the issue and who get freaked out when people start talking about hazardous materials, not fully understanding the breadth of that concept in the law and how that needs to be more effectively managed between the parties. I think there's sometimes a notion that if you just keep moving forward with the transaction, some of these issues will go away. Your problems in your deal rarely, if ever, go away, and they often get worse. Just getting a site sometimes doesn't advance your ball in any meaningful way.
Right. So define the scope, set a good foundation, and just briefly, before we move on, at what point does a lawyer enter this process? You're talking about, laying a good foundation. At what point do they enter the process, and maybe what's the breakdown in the workload? Is it all in the entitlement phase, does it seem like, or is most of it in the construction where things go wrong?
I think typically lawyers get involved around the time of contracting. So the time that the site is gotten under contract is usually when the lawyer gets involved. I would say that's probably late because at that point, so much of the deal has already decided the price, how the earnest money is going to work, what the due diligence is going to be, what the timing is going to be. I will tell you that invariably, developers are very poor estimators of time. And so what happens is they'll agree to contractual deadlines that they cannot maintain. And so then the lawyer's stuck constantly extending the deadlines, which again increases your cost because then you're having an attorney draft an amendment to a contract that if it had been properly conceived in the first place, you probably wouldn't need the amendment. And the other thing is just not thinking through how all of your pieces are going to come together, because you really have to have a sense of that by the time you get to contracting. Obviously, you're not going to know for sure, but you should have some clear variables and clear paths as to how you're going to get to a deal. And so you should have some sense of what kind of financing might you be able to get from a traditional lender, what kind of incentives might you be able to get from the municipality, how long is it going to take you to get your entitlements, how long will it take you to do your site design, what are going to be your site design issues. I think all of those things need to be quantified to some degree before you go to contracting. And what often happens is the contract becomes a chicken or the egg, which is, I just want to get the land under contract is what the developer wants to do, when really what they need to do is make sure that the foundation that they're setting with their contract is going to be workable throughout the course of the deal.
So as we kind of wrap up, I'm just curious, because we've talked about a lot of basics. Are there things that you would say are responsible for the greatest financial losses? Each of these things on their own could cause lots of financial turmoil, but are there habits or traits that you see in developers that themselves explain a lot of the wasted money that happens in development deals?
I think developers love the thrill of the deal, right? They love finding the site. They love putting their finger up in the air, feeling which way the wind is blowing, and coming up with their concept, right? That's the thrill. The drudgery of getting through from that point to a fully developed site is not attractive. It's not the fun part of the deal. It's the slog of getting to the part where you make money. And so what ultimately happens, I think, over the course of the transaction is the developer starts to lose focus on the transaction. They're on to other deals. They're sticking their finger up in the air.
Thinking about their next place.
Correct. And so they stop actively managing the project that they have under development. And what happens then is mistakes get made, things don't get done on time. And so you start getting sort of a snowball effect of this lack of attention allowing things to pile up and not get resolved in an effective way. Which
don't get handled until it is literally crisis mode.
Correct. And that is the worst time to try to solve a problem, is when there's a crisis. And one of the areas I see this particularly is in the management of third parties. And I would put lawyers in that mix. I mean, I think, developers are very good at certain things. Lawyers are very good at certain things. But sometimes without management, lawyers can run amok. They get very focused on certain issues. And if the developer is not necessarily paying attention, or going back to something we talked about earlier, fully understanding what the issues are, they can't effectively manage their third parties that they're paying to work for them. I actually worked on a transaction a couple of months ago involving a surveyor who was just making all of the decisions on a project without consulting the owner. And it was turning into a huge problem. And we kept going back and having disagreements. And then the surveyor would sort of go off and do whatever they wanted to do, as opposed to taking direction from their client, who really was the developer. And that really was a function of the fact that the developer wasn't good at managing third parties. Same thing with the developer's attorney, all the parties, that the construction contractor that was working on the site, all those people were sort of just doing whatever they wanted without operating under the auspices of the person who was really paying them. And that creates...
Because that person may not have been around because they weren't interested enough, because they were thinking about their next deal.
Correct. And looking at the deal, and I knew something about the economics of it from his perspective, he lost a lot of money in not properly managing his people. And that is an issue that I do see over and over. If you let your design professionals run amok, you can end up with a lot of designs that you ultimately don't want or don't work. And the fact of the matter is, that's not the fun part of being a developer. Having to manage all those people is not, it's not fun.
As my very last question, could you talk about some ways that if somebody's starting out or doing smaller deals, that they can ensure they are covering their basis legally, but also not spending more than their budget allows on legal fees?
Right. I think that the number one thing you can do if you're starting out is find a lawyer who you feel comfortable with, you think understands your business, is focused on you as a client, and then you can use them as a resource. And by that I mean to spend an hour talking on the phone or meeting your lawyer for coffee or whatever you might choose to do to interact with them, to get their thoughts on whatever you're trying to do. Lawyers always love to tell people what to do. That's one of the functions of what we do, right? That's our joy.
Telling people what to do since 1750.
Yes. Yeah. And so I think if you use that resource and get thoughts from your attorney as to what they foresee as being the issues on a project, how they would handle them, how they would manage the situation, it helps you go into all of your transactions more fully prepared. And getting that information again at the outset so that you can manage those issues right from the front is very effective. And again, an hour of lawyer time on the front end, talking about your project, issue spotting, thinking about strategies for managing that, is a lot cheaper than spending 40 hours on the back end trying to fix a problem. The other thing you can do is have standard contracts that you use in certain situations. If you're going to do an option or a purchase agreement that you're capable of filling in on your own, but has been vetted by your lawyer and you understand how it works and you've taken a fair approach to how you structure your contract. Certainly, if you go in with a contract that's completely buyer favorable and you have a sophisticated seller, you're going to end up spending a lot of time on negotiating. That's probably not the most effective way as a young developer starting out to spend your time. Again, you're much better off to get an hour or 2 hours of advice from a knowledgeable attorney with whom you feel comfortable than you are to spend 10 hours drafting a purchase agreement that you really don't understand. I think knowing that the lawyer's job and the right lawyer for you as a developer is the one that helps you be more successful. And so if you find the people who are willing to work with you on that basis, it's going to help you get going in a much better way, and you'll have much better footing, and you'll be able to be more successful from the outset, which means you can do more projects, right? At the end of the day, it's all about success and making money, and the right lawyer is going to want to be invested in that with you.